although this show is set in New York City, it was not filmed there. Where was the show actually filmed? Toronto. That is correct. Well done. Great job. Okay, American Crime Story. In this TV show, Sarah Paulson portrayed which real-life prosecutor of the O.J. Simpson case? Marcia Clark. Who? I heard it over here. Great job. Marcia Clark. Okay. Is it a lawyer show? I say yes, a lawyer movie. One of my favorites. In the 1994 version of Miracle on 34th Street, what was the final piece of evidence that caused Judge Harper to determine that Santa Claus could exist in the form of Kris Kringle? Let's see, who said it? So Mail is in the older version of the Miracle on 34th Street, but not in this one. Okay, sure, yeah. Sure, we'll ignore the first part of the question and you're right. Okay, so anybody for the 1994 film? I heard somebody say it. The dollar bill? A dollar bill with "In God We Trust" circled, that's right. Okay, this is My Cousin Vinny. In which state does Vinny Gambini defend his cousin in a murder trial? Alabama. That's right. Great job. Okay. Now we're looking for the movie name. All but 3 minutes of this film were shot inside the 16-foot by 24-foot jury room. 12 Angry Men, that's right. Great job, but not the question. Okay, so what score does Elle Woods achieve on her LSAT before being accepted to Harvard Law School? Nope, not 176. No. Oh, nobody's got it? The highest score is 180. 179, there it is. Great job. A very good LSAT score. Very, almost perfect. Okay, this is our last one. Okay, so from A Few Good Men, how much was Jack Nicholson paid for his 10 days of work on the film A Few Good Men? You're close, but you gotta go higher. Anybody? He said it was money well spent, in his opinion. Anybody? Okay, so I've heard 1 is too low and 10 is too high. $5 million. Great job. Yeah. About $500,000 a day. Not bad. All right, thanks guys. So that takes us through our trivia section. So thanks for participating. I think we're pretty good on trickle-ins. We'll probably get a few more, but we'll go ahead and get started.
Okay, I'm going to introduce Robert, who's already been talking. But hold on, I have to get there really quick. So I really tried to talk his wife into coming to introduce him, because she's darling. But they have 3 little kids, and so she's like, I'll type up something for you. She's like, I'll do the good stuff, and then he can tell the boring stuff. So they've been married next week. What day? 10 years. And they have 3 little kids, Chloe, who's 5, Lucy, who's 3, and Parker, who's 5 months. Robert served his mission for the church in Albania, so he speaks Albanian. So maybe he'll say a few words tonight for us. And she said, we hope to visit someday soon. I said, we'll go for your 10-year anniversary, but she just laughed. So Robert went to ASU for undergrad and law school, and while he was at ASU, he was on the wakeboard team. Being at the lake is his happy place. I don't know Robert super well, but I see videos on his wife's Instagram. They're at the lake in January. which is so crazy. Do you wear a wetsuit? Okay. No, I know. I'm gonna November, but it's oh my gosh, so sorry. Okay, this is from his wife. Other favorite things to do as a family is going to the beach in Oceanside with all the scows and cousins. Robert and Jessica love playing outside games like can jam, cross net, and spike ball. She said they're very competitive and make a great team. To know Robert is to love him. He's one of the greatest guys you'll ever meet. Grateful to do life with him. That's from his wife, not me. But she was so sweet. She's like, he's the greatest guy I know. I'd love to write something for him. So we're so excited to have Robert here. So thankful that he's taking his time and doing this for all of us. So I'm sure he has great info for us tonight.
All right, thank you. Thanks for coming, everybody. I'm excited to have you all here. Today, we're going to talk about what happens after you die. Really, what happens to the stuff you leave behind after you die, because I can answer that question for you. What is going to happen to your stuff after you die? Happy to have you all here. This is, I guess, the boring stuff, according to my wife. I have been an estate planning attorney for about the past year. I spent the first 4 years of my life as an attorney in civil litigation in 2 larger firms in Phoenix. And it was a great experience for me to learn a ton from great lawyers and to learn about, how litigation works. How do people attack contracts and these different things? How do lawyers think when they're in the middle of a litigation? And that's really helpful for when you're planning on the front end, trying to avoid litigation in the future. So it was a great experience. I'm very happy now in my own firm doing estate planning. I get to help people prepare for the future. I get to help them prepare for something that is definitely going to happen and try to make a plan that's going to protect their assets and their family for the long run. And so I love that I get to help people with that. I've been married for 10 years next week. This is my wife Jessica, Chloe and Lucy, and Parker's 5 months, so we haven't got around to our new family picture yet. When I was approached about putting on this class, I thought, if I were to come to this class and I knew nothing about estate planning, what would I want to know? That's sort of how I approached what I should prepare. And I thought, if I came here, I would think, well, what's going to happen if I die? Just what's going to happen to my stuff? And the answer to that question depends on what steps you've taken to this point to prepare. And so what we're going to do is we're going to walk through 3 different scenarios. What happens to our hypothetical family if they die, if the parents die without any plan at all? What's the process? What's going to happen to their stuff and their kids? Then what's going to happen if they have a will-based plan? And what's going to happen if they have a trust-based plan? And then we'll compare those 3 things. Throughout, I'm going to try to debunk some estate planning myths that you may have heard, and I've heard lots of times. And we'll go over what I call the estate planning toolkit, some additional documents that we prepare as a part of our packages. All the work that I do and most estate planning attorneys, we do in like a package-based system. So I have a will-based package and then a trust-based package. So we'll talk about those other documents that are a part of the package. If you have any questions throughout, since there's a lot of you here, instead of having you raise your hands and ask questions during the presentation, if you have any, you can text them to this number, and it's going to be on the bottom of all the slides. And then Julie is going to, or someone over there is going to look at them. And then at the end, if we have some time, they'll select a couple of questions that I can go over. If I don't get to any of your questions, I'll be here, and you can come up and ask me after. That's fine, too. Okay, so our first potential myth, is it true or false? Estate planning is only for older people. That's right, it's false. Really, anybody who's 18 years or older can create their own estate plan. You can put together a will or a trust, and it's for anybody who wants to make their own decisions about where their stuff is going to go and who's going to take care of their kids. If you're okay with someone else making those decisions, then if you don't make a plan, then you're going to be stuck with the default rules of the state. So it's not just for old people, because old people aren't the only people who die, right? It's for everyone who wants to be prepared for the future. So great job. Okay, so as I said, we're going to go through 3 different scenarios, and the first one is what happens if I die without any type of estate plan. And the rules for each state are a little different for what happens with your stuff. What are the default rules? And so since we're in Arizona, we're going to be talking about the Arizona default rules. Okay, and in your handout, if you grabbed the handouts, the vertical page, on the back side, there are some definitions for in case I say anything that you don't know what it means. We're going to go through a couple definitions before I hit each section, but so you don't have to write definitions down there for you. So this first word, estate. So your estate is all of the property that you own at the time you die. So that could include, your house, bank accounts, brokerage accounts, retirement accounts, life insurance policy, benefits. All of these things are includable in your estate. Those are the things that are going to need to be passed on to someone else if you are to, when you do pass away. An estate plan is a collection of documents that direct where those assets that are in your estate are supposed to go and what is supposed to happen with your family if you leave behind any minor children. An asset, so an asset, I just went over those. That's a house, life insurance policy, retirement account. Those type of things are all assets. And there's also personal property, things like furniture, TVs, those type of things in your home. Okay, intestate. So we're talking about the Arizona default rules for what happens if you die without any type of estate plan. Intestate means without a will or without an estate plan. So if you die without an estate plan, it said that you die intestate, and the default rules are called the intestacy rules for the state. So you'll hear about those. And I'm sure everyone's heard this last word, or most of you have heard the last word, probate, and maybe you've had to deal with one in your life at some point. Probate is the official court procedure of determining the validity of a will or transferring the assets of someone who died without any estate plan. So those are our definitions for this first section. Okay, so this is our family that we're going to be talking about. What happens? So if you came here with the question, what happens if I were to die today and I don't have any type of estate plan? This is what's going to happen. Okay, so we have Ron and Pam. These are the parents in the family. Ron is 47 and Pam is 45. That's what those numbers mean. Rupert is the oldest. He's 20. Daniel is 18. And Emma is 11. Okay. So Ron and Pam have $1.5 million in their estate. And you might think, $1.5 million, that's a lot of money. These guys are really wealthy, right? The thing is, that number adds up really quickly when you think of all the assets that you've accumulated over your lifetime, especially when you think about like a life insurance policy, right? So so for Ron and Pam, if Ron and Pam each have a $500 million life insurance policy and they live in a $450,000 house, if they were to die, they've got $1.5 million right there. While they were living, that $1 million wasn't theirs to use, right? And so they might not have felt like millionaires, because they weren't, but their estate has $1.5 million in it, and we need to figure out where all that money goes. So Ron and Pam pass away. Now what happens to that $1.5 million? They have no plan. Well, the state default rule says that it's going to be split equally between the 3 kids. So we're going to go $500,000 to Rupert, the 20-year-old, $500,000 to Daniel, the 18-year-old, and $500,000 that's for Emma, who's 11, but she can't receive it yet because she's a minor. And so that money's going to sit in an account until she turns 18, and then she's going to get the $500,000. Now, one of the questions that I wrote on your handout is, some questions to consider is, what would you do if you were given $500,000 or more on your 18th birthday? It's, I know what I would have done with $500,000, I would have a new boat and a truck to pull it, and that'd be pretty much all of my money gone. So that is one of the issues here with not having any type of estate plan, is there's this potential that money, large chunks of money, can be given to kids still, really. I mean, 18 and 20, they're adults, but basically kids, right? Does everyone agree with me on that? I feel like 18, 20, you're still a kid. Okay. So here's a summary of what happens, because we'll go into a little more details. But first, we have equal 1/3 shares at 18. We don't know what Ron and Pam would have wanted, but the state default rules are sort of guesses at what we think they would have wanted. And so we assume and we guess most people probably want to split their money to their kids equally. So that's what we do. Now, in order for Rupert, Daniel, and Emma to get this money, they're going to have to go to a probate court. And so it's probably going to be Rupert. He's going to go to the probate court and apply to be named as the personal representative. If you've ever heard the term executor, that's the same thing. In Arizona, we say personal representative. So that's the person who goes to court and says, my parents died without a will. This is the money in their estate, and I want to be the one who's in charge of getting it to where it needs to go according to the state rules. Okay, so there's a decent amount of, there's a lot of rules. It's a formal court procedure, and so generally when someone like Rupert goes to court in that situation, he's going to hire an attorney. So there's going to be some attorney's fees, and there's probate fees that go to the court, and then there's going to be some built-in delays. So when anyone goes to the probate court to open a probate, it's not going to be finished for at least 5 months. There's a 5-month waiting period for creditors to make claims against the estate. And that's if there's nobody challenging anything, 5 months is how long it's going to take. If anyone challenges anything in it, then it's going to take longer. Another issue that we have here is, of course, Emma. Emma's 11 years old, so who's going to take care of Emma? Because Ron and Pam didn't leave any plan, we don't know. And so, maybe it's going to be Ron's parents, Pam's parents, maybe Rupert wants to do it. There are some statutes that list who has priority, but at the end of the day, it's going to be something that's decided by the court after, all these people go to court and say, I want to do it, I want to do it. And the court's going to decide what the court thinks is in the best interest of the children, because we don't know what Ron and Pam would have wanted. So really the hallmark here of intestacy and, dying without a plan is uncertainty. We just don't know. We don't know what Ron and Pam would have wanted. There's lots of times in this situation where Rupert's off at school and Ron and Pam have already paid tons of money for Rupert to go to school. So he's already received a lot of money from his parents, and so maybe it's not fair for him to get an equal share now. Maybe Daniel has a lot of extra needs, and his parents would have given him more money. We just don't know. And so because we don't know, we have to go with the state's default rules. So that's what happens under intestacy rules. Okay, another thing. So what if Rupert, Daniel, and Emma aren't around to take that money? They aren't there to take their 1/3 shares. Maybe they died at the same time. What we do then is we find the next closest relative, and we use this consanguinity chart. One reason I included this slide is just because that's one of my favorite words, consanguinity. And so what you do is you go down the row. So if Ron is here and we're looking for his next closest relative, we go down this list to children and then grandchildren. And if there's no one, then we go up the next row, up the next column to his parents, and then down. We keep going up and down until we find someone that the money can go to. And it's also it's helpful too for me. I love this chart because I like to know, Jessica Branson in my ward is my second cousin, and I know that because we have the same great-grandparent. So it's cool. If you're interested, consanguinity, you can find charts online. Okay, so how many of you, and you don't necessarily need to answer, you just think about it, have ever heard of someone promising something to someone after they die verbally? So verbal promise, you can have this after I die. Okay, So we're going to talk about, how that could be a problem. Because we're talking about, official documents to create an estate plan. What about a verbal promise? Okay, so I don't know if everyone knows who this is Marlon Brando. So Marlon Brando, he has sort of a famous story about him in estate planning circles. So he promised to one of his housemaids that she could have one of his houses, his $450,000 house. He said, "You can have my $450,000 house when I die." So he died, and then what does the housemaid do? She stays in the house. And what does Marlon Brando's family do? They say, "What are you talking about? You don't get to stay in this house." And so they kick her out, and she files a claim in the probate court against his estate and say, "This house was mine." And what happens after that when there's fighting about in the probate court? This family and the housemaid are spending lots of money on attorneys, and at the end of the day, the housemaid settles for $120,000. So we don't know what Marlon Brando wanted in this situation because he didn't write it down. We just had a verbal promise. But we do know that if he did want the house to go to the housemaid, that didn't happen. And if he didn't want her to get anything, that didn't happen either because she got $120,000. So that's the danger with verbal promises. I've also heard stories of wedding rings being promised to multiple children. And that's, we just don't want to invite that kind of fighting after someone dies. Okay, so we've talked about what happens with no plan. And for most people, that's not a good option, having no plan. And so if you decided for yourself, okay, well, I want some type of plan, where do I start? What I like to do with anyone who comes through my door is to start with goals. I love goals just in every part of my life. I love setting goals, making a plan to achieve the goal. It's just one of my favorite things to just watch myself improve or to watch anyone improve. I love it. And so with estate planning, I like to start, I hate the idea of anyone coming in and being like, "I need a will," and me saying, "Okay, here's a will." It's just, that's not what I do. What I do is I help people create a plan that's going to achieve their goals. What do you want to achieve with your estate plan? So think about it. Think about why would I want an estate plan? What would I want to achieve with planning? What do I want for my family? And I have a couple listed here. This isn't every estate planning goal there is, but these are some that I like to talk about. The first one, a simple one, is I would like to transfer assets to specific people. If you aren't happy with the state's rules of splitting equally between your kids, then you definitely want to write down your plan. Even if you do like that default rule, you probably want to say it to make sure that everyone knows that is what you want. If you want to care for yourself during your lifetime, with certain estate planning tools, we can plan for a time in your life when you're not able to make your own decisions. We can make sure that your assets can still help you, be used to take care of you, even if you're not the one making the decision. Minimizing conflict between family members, this is my favorite one. This is one of my favorite things about practicing in this area is this thought that I can help people try to preserve their family relationships. I've heard so many stories and seen so many families that have been torn apart by fighting over money after someone died. And that's just, I think, the worst. Like the last thing that this person that died would have wanted, right? Their family to be fighting. Eliminating the need for probate. And so with certain estate planning tools, we can eliminate the need to go to a probate court to have everything adjudicated. And that's good for a couple of reasons. It costs money, there's time delays, and it's a public record. So if you're not a fan of, all the money that you own and where it goes being known to the public or anyone who wants to go look it up, then you may want to avoid probate. Passing on values. We can pass on more than just money and assets. We can pass on our values through, a plan where you write out what you want for your family. And lastly, creating lasting opportunities for family members. Some people are concerned about giving their kids lots of money. They're concerned that if I give my kid $500,000, that's not going to help him. He's going to ruin his life. For whatever reason, if he has an addiction, maybe he's just not that smart financially yet. There's a lot of different reasons why that could be a bad thing. And so there's lots of ways we can be flexible with planning, whether that's spacing out the distributions so they don't get any money till they're 20, or they get some at 20 and some at 25 and some at 30. Or we can create opportunities for them by leaving money in something like a trust that we'll talk about more, and allowing kids the opportunity to take loans out against that money that they have to pay back. So they're not just given this money, they have some accountability with it. So they have an opportunity, they have access to the money, but no entitlement. So there's lots of different things we can do with estate planning. We can be flexible, but it really just depends on the goals. And so that's why I like to start there, and make sure if you are going to go to anyone to have an estate plan done, definitely start by thinking about, what do I want my plan to achieve? Okay, so now we're going to go into what happens with a will-based plan. What happens if I were to die with a will-based plan? Okay, and I meant to mention this on the first slide. Some of you might have been wondering, why is there a goldfish on this slide? Maybe you're just like, oh, there's a goldfish, who cares? Maybe you were wondering. My wife, when I showed her, she's like, why is there a goldfish on there? So I chose a goldfish because, have any of you ever heard of the expression, or I've heard it used most this way, that quarterback needs to have a goldfish memory? Anybody ever heard that? Anybody ever heard of a goldfish having a short memory? Okay, so the classic myth is that a goldfish has a 3-second memory. It's like, see something, swims away, back, it's forgotten, right? So there have been some studies that I read about that have shown that a goldfish can remember things for as long as a month. It's like, oh, okay, so it's not a 3-second memory, it's longer than that. But the myth persists, even though it's been disproven. And that's what happens with a lot of these estate planning myths as well. You can go to someone, you can learn that that's not actually true, but you're still going to hear this forever. It's just a myth. That's how they work. Okay, so this next one, so true or false? Drafting a will eliminates the need for formal probate court proceedings. This is false. That's right. If you remember or looked at the definition, one of the purposes of a probate court proceeding is to determine the validity of a will. So is the will valid? We got to go to court to make sure, or so the court can say, yes, that's a valid will, and we're going to go forward with it. Okay, so let's take a couple more definitions before we go into our explanation of what happens if I were to die with a will-based plan. So the first definition, a last will and testament. A last will and testament is a document that describes the intentions of the testator. The testator is a person who drafts a will. And so that's not your attorney, it's you. If you go and you create a will with an attorney, you are the testator. A guardian is someone who is charged with the responsibility of a minor child. And a holographic will. So anybody ever heard of a holographic will? Raise your hands. Anybody? Okay, a couple people. So a holographic will is a handwritten will. So I have an example here. If any of you ever watched the show Parks and Recreation, this is from that show. Ron Swanson is a character in the show. And he wrote, "Upon my death, all of my belongings shall transfer to the man or animal who has killed me." Some random symbols, signed Ron Swanson. So this will, if Ron was 18 years old when he wrote it, is valid. It's a valid will. It would be difficult to enforce, to find out who killed him, and there would be some other legal issues with that, of course. But the point of me including this is just, that's a valid will. If you want to write your own will, you handwrite a will and sign it, it's valid in Arizona. Very easy to challenge, and it's very easy to make some big mistakes, and so it's not necessarily advisable. The rule is there for the scenario when someone's like on their deathbed and wants to write something really quick before they die, and even that's not a good idea, so I'm not a huge fan of it, but it is an option. Okay, so back to our case study. Now Ron and Pam, we have the same exact scenario, same 3 kids, same ages, same amount of assets in the estate, $1.5 million, but now they have a will, and the will is going to direct where things go, okay? So let's go through our summary again. So Ron and Pam actually liked the idea of everything being split equally between their 3 kids. So we have 1/3 to each kid. And so you might look at that and say, okay, so what's the point of having a will, right? If we're getting to the same results, what's the point? The point is, now we know. Now we have some certainty about what they actually wanted. You know, we can't, it's much more difficult now for anyone to come in and fight about where the money is being distributed, because we have a written document signed by Ron and Pam that's witnessed and notarized that says this is where we want our stuff to go. And so that's what the court is going to do. They're going to enforce that will for equal 1/3 shares to each of the 3 kids when they turn 18 years old. So, you know, as we said on the last slide, there's still probate fees that are going to need to be paid. But there's less opportunity for challenges here, because we know what they wanted. We've appointed Rupert as the personal representative. So now no one else can come in and say, no, I'm supposed to be the personal representative. They've appointed Rupert. And so we don't have to worry about that. But we are still going to have the 5 months delay, and we are still going to probably have some attorney's fees that are going to need to be paid, because it's still a difficult process that Rupert's going to go through. But we're definitely solving one big issue here with Emma. Ron and Pam have named a guardian for Emma. They've named Pam's sister, that's whoever, but they've named someone. So now there's not that same opportunity for fighting over who's going to be taking care of Emma, or where does Emma go right after they die. We have a system in place now for who's going to take care of Emma. So that's obviously much better. We have some certainty, right? That's the big difference between not having a plan and then having a will. Is there some certainty about where everything is supposed to go, who's going to take care of Emma, all of those things. Okay, and so I've mentioned a little bit about how the probate process works, but I want to go into a little bit more detail just so you can understand kind of what happens. So with the will, I mentioned that Rupert was named as the personal representative. So what does that mean? What's he supposed to do? Rupert is going to go to the probate court, and he's going to apply to be appointed as personal representative. You know, just because the will says he's personal representative doesn't mean he is. A judge still has to say, yes, you're the personal representative. And so that happens by him taking the will to court and filing that application. After that's approved, he's applying to probate this will. And the next step he has to do is he conducts an inventory. So he has to gather up everything that's in the estate, you know, all the policies, all of the real estate, whatever it is, bank accounts, and conduct an inventory. So that means he's got to assign a value to everything. So that probably includes hiring a professional, a valuation expert who's going to come in and say, this house is worth this business interest is worth this TV is worth this, all of those things. So we figure out what is everything worth. So we have a number for what's in the estate. His next step will be to notify all the creditors so that they can make claims against the estate. So they can say, oh yeah, he actually owes me this much money. That's their time to do that. If they don't do it in the 5 months, then they lose the opportunity. So that's why there's that 5-month period. After the 5 months is over and there's no more claims against the estate, the personal representative is in charge of distributing the money to whomever is supposed to receive it under the will. And so in our situation with Rupert, Daniel, and Emma, he's going to distribute the money to himself, to his brother, and then he's going to have a conservator appointed who's going to be in charge of those funds for Emma until Emma turns 18. So that's the probate process. That's the simplified version. I didn't include everything because I didn't want to go into super deep detail, but I want you to understand just a little bit more about what the process actually looks like. Okay. So next question. So estate plans do not need to be updated. Set it and forget it. You heard that? That is false. A lot of people create an estate plan and then they throw it in the back of their safe or in a closet, and they say, "I'm good. I have an estate plan. I don't need to worry about it anymore." The problem with that is things change, right? Like, we have huge life events that change where we might want things to go or who we might want to take care of our kids. So I want to tell you a story about how easy it is to mess up on where you want your stuff to go, or to accidentally disinherit a child. Okay, so Heath Ledger, he was an actor in Hollywood, right? You've probably seen some of his movies. He became famous and was successful at a pretty early age, and so he received some good advice that he should put together a will. And so Heath Ledger put together a will. At the time, he wasn't married, and so he named his mother and his sisters as the beneficiaries of his will. So they're going to get all of his money when he dies. Okay, so that's in 2003. In 2005, he has a daughter, okay, and does not update his will. So the beneficiaries are still his mother and his sisters. In 2008, Heath Ledger unfortunately passes away. And so now, no updated will. His will says my estate is going to be split between my sisters and my mom. So what does his daughter get? She doesn't get any of the estate. And I'll tell you, it's not a terribly sad story. We're okay because Heath Ledger did take out a life insurance policy and named his daughter as the beneficiary. So she did still receive money, and actually a good amount of money. But she didn't receive any of his $20 million estate. And so, like, the issue is just, maybe that is what he wanted, but maybe not. We don't know because he didn't update after he had a kid. And so there's a lot of life events that are good times to review your estate plan. I advise all my clients to review their estate plan every 2 years, just to make sure everything's still happening the way they want. But there's major life events that should make you think, maybe I need to change this too. Having another child is one for sure. If any of your children get divorced, or if you get divorced, these are major life events that are going to change how you want your stuff to be distributed after you die. And if you don't update your plan, then that's not going to happen in accordance with what you want to happen now that your circumstances have changed. I'm sure you can think of some other things that would make you think, oh, maybe I don't want things distributed how they are under my will anymore. Okay. So we've gone through our first scenario of no estate plan at all. Our second is having a will-based plan. And our third is a trust-based plan. I left this one for the final because it's the best. You can probably assume that's what we're doing. We're starting from the worst, going to the best. And so we're going to be talking about what happens if I die with a trust-based plan. Okay, so the first term we're talking about is the revocable living trust. So when I say trust up here, I'm always going to be talking about a revocable living trust. There's more than just a revocable living trust. There's other types of trusts, but this is what we're talking about today. For most people that come to me to do their estate planning, this is the tool that I suggest because it is just such a great tool for managing your assets after you die. Okay, and the definition is included in your materials, and I'm not even going to say it because I don't want to confuse you. I'm going to go to the next slide and explain how a trust works. And so we're going to just stick a note on that one and wait for the next slide. The trustor or the trust maker is the person who creates the trust. So again, not the attorney, the person who comes in to see the attorney to make the trust. Okay, it'll be titled in their name. The trustee is the person who has control over the trust property. Okay, so they're the person who, when property is put into the trustee is the one who's now has authority to control that property. Use it, give it away, all of that. And a beneficiary is anyone who has a right to withdraw or receive property from the trust. So, how does a trust work? Now we're going to talk about what it actually is. What a trust does is it creates a fiduciary relationship between certain people, between the trustor or trust maker, the trustee, and beneficiaries. That's confusing. That was the part I said I wasn't going to say. I decided to say it anyway, sorry. We're going to talk about so this is the simple way of thinking about what is a trust. A trust is basically a bucket that can hold your assets for you, okay? So when I created my trust, this is it right here. This is my trust binder. This essentially allows me to move property into my trust because I've created this. So my home before was titled in my name. As, you know, the home where I live was titled in Robert Skousen's name. Now it's in the Robert Skousen and Robert and Jessica Skousen Living Trust. Okay, and what that means is, you remember we talked about when someone dies, their estate is everything that's owned by them at the time they die. Okay, so if you own anything in your estate at the time you die, it has to go through probate court to be moved to anyone else. And that's a really important rule, right? That's how we ensure that property is properly transferred to the right person, and you're not just grabbing property that's out there because someone died. You know, we need to have a proper procedure for transferring property. Okay, so that's why probate court exists. If I move my house into my trust and say whoever is the trustee is in control of that trust property, that means that property is not in my name when I die. Okay, so if I were to die today, my home is owned by this trust, and the successor trustee who comes in after me, in this situation it's Rupert, they now have control of the property that's owned by the trust. So they can sell it, so they can distribute money to other people, or do whatever the trust tells them to do with it, but they have control of it without needing to go to the probate court first. So that 5 months is not a problem. The probate court fee is not a problem. Attorney, they will go to an attorney still to help them know what the trust says, but we are avoiding, the 5 months, and we're avoiding the just formal public court procedure. So that's how a trust works. Think of it as a bucket. I have my trust bucket, and now that I've created it, I need to put property into it. Okay, so that's what happens. So we have our trust bucket. This owns the property now, and we're moving stuff into it so that when we die, we don't have that property in our name anymore. So here we are back to our scenario. We have Ron and Pam, same amount of money in their estate, but they moved it into their trust bucket before they passed away. Okay, so now what's going to happen when Ron and Pam die? Well, Ron and Pam have decided that they want to have flexible distributions to their kids at 18, 25, and 30. So that means, okay, when Rupert, or when anyone turns 18, they can get a 10% distribution of their share when they turn 18. Okay, so when Ron and Pam die, Rupert and Daniel, their shares are each worth $500,000. So if they get 10% of that at 18, they're going to get $50,000. Okay, a much smaller amount of money, so we're not quite as worried about them, making really poor decisions and wasting all of the money that their parents worked so hard to get for them. So, that's one benefit of this for sure. And then they'll get another distribution at 25 and another at 30. Okay, well, what about Emma? Emma's 11, so what happens to her share? So her share stays in the trust. And really the rest of Rupert and Daniel's share stays in the trust. And Rupert's in charge of that money. So Rupert can manage the money in the trust. He can invest it. That money should grow. It shouldn't just sit somewhere, it should grow. And so this money is going to continue to grow, and the trustee who has control over the property, he can help Emma out. He'll have authority to pay for certain expenses on Emma's behalf. The typical standard for the trustee is they can make payments to a minor for their health, education, maintenance, or support. Now, maintenance and support are pretty broad, right? And so that means he can use that money for lots of different needs that Emma might have. If Emma needs braces, Emma wants to go do dance. There's all these different things. That trust money is there to take care of the kids. And so Rupert then can use the money to do that because the trust is going to grant him authority to do that, okay? We already mentioned this. So we don't need to go through a formal probate court administration because everything's in the trust. Ron and Pam don't have these assets in their name, so we don't need to go to the probate court. Again, we have a named guardian. So Ron and Pam have named someone to take care of Emma, so we don't have to worry about, who's going to come in and take care of Emma. We know. And then the trust document is going to have instructions for the trustee. So it's going to tell Rupert, this is what I want you to do with this money. This is whether it's, pay for schooling or, whatever it might be. There's going to be instructions in there that are from the trustors, the people who made the money for the kids. Okay, so this is what I love about trust planning. I told you I love goals, and I love just having a plan to achieve goals. With a trust, we're planning for everything. We're not just planning for, okay, when I die, my stuff goes here. We can do a lot more flexible planning. And so I like to think of it as 5 different phases of life that this trust is effective for. Okay, and the first one is the day I sign my trust. I move things into my trust. Now my trust is effective, right? But I'm the original trustee. So I retain control of everything in my trust. It's sort of business as usual, but I do have this trust created so that I'm ready. And I can have some peace of mind from knowing there's a plan in place. If anything happens to me, I don't have to wonder, what's going to happen to my stuff? Are my kids going to fight? Is my other family going to come in and try to fight? I don't have to worry about it as much because I have a plan that clearly lists and clearly describes what's supposed to happen. In phase 2, so phase 2 of the trust is not necessarily in order. Let's say there's a time in my life where I get old and I start to lose some of my ability to make my own decisions for whatever reason, dementia or Alzheimer's or whatever. My trust will instruct my next trustee to take over, to take control of my trust property, but then to use it for my benefit. So that property is all there, and I've named someone who's going to use it to take care of me, whether that's putting me in a home, or I could say, do not put me in a home. I want to stay in my own home, send somebody there to take care of me. So I can list out what I actually want, but we have a plan in place for when I'm incapacitated is what we call it, when I can't make my own decisions anymore. It's just so much better to have a plan for that now my family doesn't have to think about it. My family doesn't have to go like, oh, what should we do about crazy dad who's, probably shouldn't be driving anymore and whatever. There's a plan in place that I created. And so they know that I'm happy with it. I made the decision already. They don't need to make the decision at a very difficult time. That's one of the big things with estate planning is you get to make your own decisions. Court's not making them. Your family's not making them at a difficult, grieving time. It's you. So, that's what I love about it. Let's plan now so we don't have to worry about it in the future. Okay, phase 3 for a married couple is when the first of the 2 spouses dies. So when the first spouse dies, the surviving spouse retains control as trustee, and there's a couple options here. When the trust is drafted originally, it can be drafted in a way to where the surviving spouse retains complete control over everything, and they retain complete control to change or get rid of the trust if they want, because it's a revocable. I didn't talk about that really. Revocable means changeable. So if we draft the trust that way, the second spouse can do whatever they want with the money. The reason we don't plan this way is sometimes this surviving spouse marries someone else. And then this someone else that comes in is very persuasive about where the money should now go. Maybe it should go to the new spouse's kids or all to the new spouse. And then the kids of the spouse that passed away might not get the benefit of all this money that they worked for in their life. And so we can plan so that, we can do some planning to make sure that doesn't happen. Phase 4, this is sort of like our will scenario where both of the spouses have now passed away. The trust then directs the new trustee to, the new trustee has direct it. They have instructions from the trust on what they're supposed to do with the trust property now. So like the will scenario, but of course we're not going through probate court anymore. The trustee just has immediate authority over all the property in the trust. And then phase 5, we like to plan for everything. So we're going to have a plan for you name your original beneficiaries of where the stuff is supposed to go. Well, what if they're not there anymore? Now where do we want it to go? Are we donating to a church? Are we donating to a charity? Other family members? We're just planning for everything. And that might be hard to think about. A lot of people, I think one of the main reasons people don't get around to doing their estate planning is they don't want to think about dying. They don't want to think about themselves dying or their family members. But it's my job, so I do it a lot. So it's easier for me. But it's really, I think, just such a great gift you can give to your family to prepare and to take the time to make these decisions and think about it so that they don't have to when it's so difficult, when you're gone. So those are the 5 phases of the revocable living trust. Okay, so here's our comparison of the 3 plans. Okay, if you just want your assets to go somewhere, any of the 3 plans will work. If you don't have a plan, your assets will go somewhere. But if you want to decide where they're going to go, then you're going to need some form of plan, whether that's a will or a trust. If you want a clear plan, so people aren't wondering what you actually wanted, okay, you need either a will or a trust. Peace of mind, that's, again, there's huge peace of mind that comes from having a plan and knowing what's going to happen to my stuff, just not having to wonder. Because I'm sure, that's something that people wonder, what's going to happen to my stuff and my family when I pass away. If you have a plan, then you know what you've decided and where things are supposed to go. If you want to do flexible distributions, that can only be done with a trust. If you want to give property to kids when they're older than 18, a trust is the way to do that, and certain percentages. If you want to avoid probate court, again, that's only through a revocable living trust that you can do that. If you want to provide financial protection for those minors, make it really easy for the trustee to pay for expenses on behalf of minor children. Again, that's the trust. That's where the trust is best for you. And then planning for incapacity. A will doesn't help you if you get to a point where you can't make your own decisions. Your family's going to have to figure out, well, okay, now who's in charge? With a revocable living trust, you get to choose who's in charge instead of your kids trying to figure it out. So that's definitely preferable for most people. Okay, so another goldfish slide. So trusts are only for extremely wealthy people. Has anyone thought that? I've heard a lot of falses, and that's great because they are, that it's completely false. But I'm sure that some of you have heard, whether it's like on TV shows or whatever, of like trust fund babies, trust fund kids. And when you hear that, you think, oh, like this super wealthy family, right? Has all this money, and they never have to work a day in their lives. Like that's what people often think about when they think of trusts. But that's not the only people who have trusts. Trusts, like I said at the beginning, revocable living trusts are the best tool for most people. Almost everyone who comes to my door, I suggest they should have a trust. There are some people who I say, a will is fine for your situation. You don't need to have a trust. But for most people, the trust is the best tool to achieve what they want. And so, no, not for extremely wealthy people, just for people who want to have a plan for what happens to their stuff and who want to, provide a plan for their kids, especially minor kids, or, if they want to do some flexible planning. The revocable living trust is the plan to use. Okay, so now I'd like to tell you about, I've spent all of today so far talking about how. how are assets distributed if someone dies in one of these three plans? What do these words mean? Now I want to talk about the why for me. Why do I do this? And a great way to explain this is actually with a story of my friend Greg. So Greg is an attorney in Florida. He's a friend of mine. One night, he received a phone call from his sister, and it's a sad story. So he was, letting you know. He got a story from his sister that her husband had passed away. She said, "Greg, I need you to come here. I need your help. My husband's passed away. He just had a heart attack." And so, it's middle of the night, but he's a good brother. He's a good person. He packed up a bag and he drove 3 hours to go be with his sister. And so he gets to his sister's house and he says, "I'm so sorry. I'm an attorney. I'm normally good with words. I don't know what to say. I'm so sorry. Like, what can I do to help?" And she walks over to her table and she grabs a binder that looks like this one. And she says, "Deal with this. Like, you take this and you deal with it." And so my friend Greg, he takes the binder and he opens it, and inside is a list of all of the assets that his brother-in-law had owned. And inside was instructions on what is supposed to happen at his funeral. Everything. Who's supposed to carry my casket? Who's going to be speaking? I've already paid for this here. These are the numbers you call. And so everything all of the business side of what needed to happen with his stuff and his body were decided already by him, and the instructions were so clear. And my friend Greg was so grateful. Like, I think he already loved his brother-in-law, but he gained so much respect for him for taking those steps to take care of his sister, so that he could come in. My friend Greg was able to come in and call the people that he needed to call and make the arrangements that he needed to make that were already done. No one had to make these difficult decisions. His sister was able to just grieve and think about, just like the relationship that she had. And she wasn't forced to make really difficult decisions at this really difficult time. And this experience is part of what led Greg to leave his practice, what he was doing before, and start doing estate planning. He said, "I can be an estate planning attorney. That's something I can get behind." And I don't have the same story, but I feel the same way. I've had a similar experience when I started doing this practice after leaving litigation and coming here. I realized that I can do something that aligns with what I care about. And I can help people create plans that are going to protect their families and that are going to give them peace of mind, knowing that there's a plan in place for if anything were to happen to me. And, we can protect against families fighting each other over sometimes small amounts of money and families ruining relationships. We can't guarantee that, but we can do the best we can to try to protect. And so I'm really grateful that I found this practice because I truly enjoy it. I'm passionate about it. I love that I get to truly help people. That's why I went to law school, and I didn't feel like I was doing that necessarily before. But now I feel like I am. And so that's my why. That's why I do estate planning. Okay, and now we're going to spend some time talking about other tools in the estate planning toolkit, which is why there's some tools up here. So here are some definitions about these other tools that we use in estate planning. So we have a power of attorney. A power of attorney grants someone else authority to act in your name. So if you own a company and you're the only one that can sign checks and something happens to you so you can't sign those checks anymore, who's going to sign the checks? If you don't have a power of attorney, the answer to that question is no one, which can be really bad depending on the business you're in. A medical power of attorney is very similar. It grants someone the authority to make medical decisions on your behalf. So, same as the power of attorney, but specific to just medical decisions. A living will is a medical directive that instructs a medical professional, like a doctor, So it's for a very specific situation. So if a doctor determines that you are in a vegetative state and you're not coming back, the only reason that your blood is pumping is because a machine is pumping your blood for you, a living will says, if I'm in that situation, I don't want anyone in my family to have to decide whether or not to keep me alive. I'm just going to make the decision now that if the doctors have concluded I'm not making it back, I don't want my family, because someone has to say, we're going to pull the plug. The doctor can't do it. Someone has to say it. And so if you don't execute a living will, sign a living will, then someone in your family is going to have to make that decision, and which can be really hard. And so we generally include those in both the will package and our trust package. And then a personal property memorandum is a document that lets you assign personal property. And these are really cool things like wedding rings. For me, it's my wakeboard and other stuff like that. If you have specific items that you want to go to specific people, a personal property memorandum is a part of your trust or will, and you can use it to assign these items of personal property to specific people. So we already talked about what these are. We're going to talk about in a specific situation that you may not have thought about before. So Ron is Rupert's dad. So all of Rupert's life, Ron has been able to make decisions for Rupert. Okay, well, Rupert's 20 now. Okay, if Rupert gets in an accident and he can't sign his own name, make decisions for whatever reason, Ron can't make those decisions for him without a court appointing him as the conservator or guardian over Rupert. So unless there's a power of attorney in place. And so power of attorneys are common for adult children to name somebody, often their parents, so that in those situations that might arise, they can make the decision on their behalf. Probably more common is this one. It's a medical power of attorney. So if you have an adult child who gets into an accident or whatever, is in the hospital, and they can't make their own decisions, just because you're their parent, Pam is Rupert's mom, he can't go make a decision on what medical procedure needs to take place because she hasn't been granted medical power of attorney. Or if she doesn't have a HIPAA release from Rupert, then the doctors can't even share information with her, right? So he needs to do that first because now he's an adult. He's not a minor child anymore. So those are other documents that we prepare because we're planning for everything. We want to make sure that we have a plan in place for all these different things that could happen in the future. And so that is pretty much everything that I wanted to go over today. We have a couple questions that we'll try to answer. Thanks for writing them down. Okay, that's a great question. So how are beneficiaries taxed on assets received if there's a trust or a will? So inheritances, you may have heard of a death tax, an estate tax or a death tax. The amount of money you have to have in your estate to pay estate taxes is really high. Right now, it's around $12 million for an individual and $24 million for a married couple. So if you have less than that, you don't have to worry about estate taxes. It's really less than 1% of the population has to worry about estate taxes. So all that money that goes to those kids goes to them tax-free. And if there was a tax issue, first, you should have an attorney help you plan to minimize those taxes. And second, it would be the estate that pays the taxes, not the beneficiaries. So they receive the money tax-free. Can a life insurance policy be changed so the trust is the beneficiary? Yes, and that's what we do. When I have a client who has a life insurance policy, I instruct them, this is how we fund the trust, put things into the trust. So we name the trust as the beneficiary so that everything gets put in the same bucket. One of the handouts that you might have seen is called a personal asset sheet. So I filled that out and include it in the trust packet for all of my clients so that whoever's the new trustee knows where everything is. It just makes life a lot simpler on them. They know where everything is. They know the policy numbers. They can call the right people to make sure everything makes it into the trust. Some people think like, oh, okay, well, my life insurance policy is still going to my kids. Why does it matter if it goes into the trust? Well, it matters if you want to have flexible distributions, if you don't want them to get all this money right away. So you can retain some control over the property if you send it to the trust. instead of to the beneficiaries. Okay. What happens if some assets aren't named in a trust, such as a bank account? I won't get too specific on this one, but in a trust package, we always include what's called a pour-over will. And the pour-over will is kind of like a backup plan. It says, everything that's not in my trust right now, I want to be put into my trust. And so it's a will. It will need to go through probate court, but it's very clear. It says, whatever didn't make it into the trust yet, I just want to be put into the trust. So it's a really simple will in that way. Let's see, can a legally executed trust be contested by a disgruntled heir? Yes, it can. We do the best we can, and this is why we also encourage transparency. We encourage clients to say, like, hey, talk to your kids, tell them where the stuff's going to go, so that they are not shocked and disgruntled. Let's see. What happens if an heir doesn't want an asset willed to them or given to them with a will? I mean, so in this scenario, the beneficiary or the heir, if they don't want it, it's really up to them. If they don't want it, they can give it to someone else, but it was given to them. They can give it to someone else. There's not really much else that they can do. So that's what happens in that scenario. Okay, let's see. How much does it cost to set up a simple family trust? Okay, so yeah, I didn't talk about fees at all. So attorneys are kind of, there's a range, right, for whoever you go to. My fees are kind of about average. For a will package, for a married couple, I charge $1,500. And then for a trust package, it's between $2,500 and $3,000 and $4,000, depending on different factors. But it's generally around the $3,000 range. You can go to someone and they'll charge you $10,000, and you've probably seen the signs on the street, or you can get one for like $400. It depends on what you're looking for, what type of service you're looking for. If someone's charging you $400, I can't imagine they're spending that much time with you. So, but that's kind of how those fees work. They are flat fees. Most attorneys do this on a flat fee basis, so you know right up front how much you're going to spend. Okay, that's a little specific. Okay, is a living trust agreement required to be filed or recorded with a government agency? No. So there's no recording requirement. Once you create the trust, I created this trust and I just keep it in my house and it's good to go. It's ready. It's effective right now as soon as I sign it and have it notarized. Should an executor, so this is of course a personal representative or a trustee, be compensated from the proceeds? So this does take a lot of work. We went through the probate process. We talked about it. And we talked about what a trustee does. In some cases, that's a lot of work. And so trustees generally have, we generally have provisions that allow the trustee to be compensated. And depending on the trustee, a lot of them will waive the compensation. It just depends. If it's a family member, often they'll waive the right to that compensation. But it really depends. Should you also name an alternative executor in case you can't function? So yes, we don't ever just name, this is my personal representative. We name, this is my personal representative, this is my second choice. Sometimes this is my third choice. Same for guardians, same for trustees. We like to have multiple choices because we can't predict everything that's going to happen. We do try to update plans too in case something happens to someone, but we also just like to have backup plans built into our plan. And last question is, how do you know which creditor to contact? So that depends on if the trustor or the trust maker left any information about debts that they owe. And if they didn't, then there's some requirements, some like notification requirements that you have to go through that the court helps you with for how to make sure that everyone is notified that these people died and they can make some claims against the estate. Sometimes that's like posting in a newspaper or whatever else that might be. But so that's how that works. Oh, I have more. Okay. I don't know how long. Okay. Why are loans to heirs a good idea rather than gifts, and how do they work? So that's a great question. So remember when we were talking about estate planning goals, one thing that I mentioned is you can create lasting opportunities for your family instead of just giving them money. And so if you wanted to create a trust that has this function that can give loans to people, you can do that. Now, but why would you do it? Well, think about it. Think about what's really the harm in giving someone in your family a ton of money. One of the real problems is they receive that money with this sense of entitlement if it's just given to them, right? It's like, oh, okay, I just have all this money, I can blow it. I can go to Vegas, right? There's no limitation on what they're going to do with it. There's no accountability there. It's just an entitled gift. If it's a loan, now your beneficiaries can still have access to the money, if they want to start a business, or if they want to go to school, or buy a house. They have access to this loan that maybe they couldn't get from a bank, but they can get it from this trust, right? And so they have the opportunity to better their lives, but there's still accountability attached to it so that they have to pay it back. We get rid of the entitlement mentality. And so that's one of the main benefits of doing something like that. Is Arizona a community property state? Yes, it is. So that means that if you're married, all the property that you own and your spouse owns. Doesn't matter if I were to buy a car today and I just titled it in my name, my name's on the title, my wife owns it still because we're married. That's how community property works. And so Arizona's a community property state, okay? There's a follow-up question. It says when one spouse dies and there is a will, the surviving spouse makes decisions. They do, but it also, if the will says, and I'll use myself again as an example. If I have a will and I die and my wife is still surviving and my will says, I want my wakeboard to go to this person, my wakeboard's going to go to that person, right? That's my right with my will to direct where my assets go. I can't say everything I own is going to my brother Richie because I don't own all of my stuff completely. I own it 50% with my wife. And so that would be, not advisable. We'd probably have some problems. But what would have to happen is someone would come in and value everything, and we'd have to split it and figure out a way for my brother to get half and my wife to get the other half because it's hers. I can't give away her stuff. So that's how that works. Is that it? So that's it. Those are all the questions. Thanks for coming and listening to my presentation. I hope you learned some stuff today. So thanks.